For what purpose does the gentleman from Arkansas seek recognition?
Mr. Speaker, I move to suspend the rules and pass the bill H.R. 1101 as amended.
Clerk will report the title of the bill.
H.R. 1101, a bill to amend the Lumbee Act of 1956.
Pursuant to the rule, the gentleman from Arkansas, Mr. Westerman, and the gentlewoman from California, Ms. Kamaliger Dove, each will control 20 minutes. The chair recognizes the gentleman from Arkansas.
Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and to include extraneous material on H.R. 1101, the bill now under consideration.
Without objection.
I yield myself such time as I may consume.
The gentleman is recognized.
Mr. Speaker, when we talk about tribal recognition bills, it often comes with a lot of passion. There are people who support the bills, there are people who oppose the bills, and it's hard to get consensus on these tribal recognition bills. But as we consider this bill today, I just want to lay out the facts of what's at stake here in this particular tribal recognition bill. H.R. 1101 would extend federal recognition to the Lumbee Tribe of North Carolina and remove a statutory bar that has impacted the tribe since 1956. According to the tribe, this statutory bar has prevented them from being federally recognized through any administrative procedure. Under the legislation, the Lumbee Tribe would be eligible for services, benefits, and immunities available to other federally recognized Indian tribes. In 1956, an act of Congress designated certain Indians as Lumbee Indians of North Carolina. It declared that they shall enjoy all rights as citizens of the state of North Carolina and the United States. But in 1989, the Department of the Interior solicitor issued an opinion stating that the 1956 Act effectively denied the Lumbee Tribe eligibility to petition for recognition under the federal acknowledgement process at the department. In 2016, the Department of the Interior solicitor withdrew the 1989 opinion and replaced it with a new opinion stating that the Lumbee Tribe may pursue federal recognition under the current administrative procedures for federally recognizing a tribe. This complex history has created legal confusion, and the Lumbee Tribe has chosen to seek federal recognition through Congress rather than apply through the federal acknowledgement process. H.R. 1101 would use Congress's plenary power over Indian affairs to federally recognize the Lumbee Tribe. I would like to thank the sponsor of this legislation, Representative Rouser, for his work on this bill. I urge support, and I reserve the balance of my time.
Gentleman reserves. Gentleman from California is recognized.
Thank you, Mr. Speaker. I rise in support of the Lumbee Fairness Act, which would extend federal recognition to the Lumbee Tribe of North Carolina. The state of North Carolina formally recognized the Lumbee Tribe in 1885, and the tribe has been seeking federal recognition from the United States for nearly 140 years. Mr. Speaker, that is a long time. Legislative efforts to provide federal recognition to the tribe over the years have been led by both Democratic and Republican sponsors and have historically passed the House with overwhelming bipartisan support. The tribe has time and time again shown that they are a distinct, self-governing Indian community and that they are worthy of federal recognition. It is long past time that Congress extends these rights to the Lumbee Tribe of North Carolina. I ask my colleagues to support the bill, and I reserve the balance of my time.
Gentlelady reserves. Gentleman is recognized.
Mr. Speaker, I yield 5 minutes to the gentleman from North Carolina, the lead sponsor of the bill, Mr. Rouser.
Gentleman is recognized.
I thank my friend, the gentleman from Arkansas. Mr. Speaker, I rise in support of my bill, H.R. 1101, the Lumbee Fairness Act, to give the Lumbee Tribe of North Carolina the full federal recognition they have been unfairly denied for decades. The Lumbee Tribe, comprised of 55,000 members, is the largest American Indian tribe east of the Mississippi River and the 9th largest in the nation. Throughout the recorded history, the Lumbee have called southeastern North Carolina home, spanning Robeson, Scotland, Hoke, and Cumberland counties. Now, despite their long history and cohesive culture, the Lumbee Tribe has never had access to the same resources exercised by every other federally recognized tribe. During the termination era, when Congress ended the federal relationship with 60 tribes, the Lumbee Act of 1956 recognized the tribe's existence yet denied them the federal rights and protections afforded to other federally recognized tribes. This includes access to benefits from the Indian Health Service and support from the Bureau of Indian Affairs. And sometimes it's quite helpful to go back and see what the statute actually says. Public Law 571 specifically reads that nothing in this act shall make such Indians eligible for any services performed by the United States for Indians because of their status as Indians, and none of the statutes of the United States which affect Indians because of their status as Indians shall be applicable to the Lumbee Indians. A bit wordy, but very clear and very to the point. Beginning in 1978, the federal government began rectifying the damage done during the termination era, establishing processes in which tribes could regain federal recognition and privileges. The Federally Recognized Indian Tribe List Act established 3 ways in which an Indian group may become federally recognized: by act of Congress, by the administrative procedures established by the Department of the Interior, and by decision of a United States court. Since then, Congress has stepped in and recognized 23 tribes through legislation, reestablishing their relationship with the federal government. Unfortunately, given the language of the Lumbee Act of 1956, only an act of Congress can establish the federal rights and privileges of the Lumbee Tribe. Some point to the administrative process as a path forward for the Lumbee Tribe, but the language of the 1956 Act, which I just read, has acted as a law of the land, barring the tribe from gaining their due privileges. The fundamental point is this: Congress wrote a law that terminated the federal relationship with the tribe, and Congress is the only entity that can restore that recognition. The administration process has quite honestly proved to be a dead-end street, and simply because of that statute. The Lumbees leadership and members work tirelessly every year to mobilize support to move the legislation that is before us today. The bill has been introduced in Congress more than 30 times with broad bipartisan support in the House and Senate. Through more than a dozen congressional hearings, documentation has consistently affirmed the Lumbee Tribe as a distinct, self-governing Indian community. In each of the last 11 Congresses, legislation has been introduced to grant the Lumbee Tribe the full recognition they deserve. In the last 2 Congresses, the House passed this legislation under suspension. And beyond Congress, the Lumbee Fairness Act has the support of 236 tribes across the country who have repeatedly cited the unfair treatment of the tribe under the 1956 Lumbee Act. So all this is to say, Mr. Speaker, this needs to be done. I want to thank the House leadership, particularly Speaker Johnson, Majority Leader Steve Scalise, for bringing this bill forward for consideration today. I thank Chairman Westerman and his committee for their diligent work on all issues, particularly this one. Their efforts have not gone unnoticed. Today, the House can take a great step forward to right the wrong of the unfair and unjust treatment of the Lumbee Tribe once and for all. I urge my colleagues to support this legislation. I yield back.
I reserve.
Gentleman reserves. Gentlewoman from California is recognized.
Mr. Speaker, I have no further requests for time. We are prepared to close. I reserve.
Gentlelady reserves. Gentleman is recognized.
Mr. Speaker, I yield 1 minute to the gentleman from North Carolina, Mr. Hudson.
Gentleman is recognized.
Thank you, Mr. Speaker. I rise in support of H.R. 1101, the Lumbee Fairness Act, which rights an historic wrong and provides long overdue federal recognition for the Lumbee Tribe. My family goes back 7 generations in Robeson County, which is the home of the Lumbee people, and I represent many Lumbees in Hoke and Cumberland counties. The Lumbees have deep cultural roots and traditions in our state that have made significant contributions since North Carolina fully recognized the tribe in 1885. Though Congress recognized the Lumbee Tribe in 1956, they were discriminated against like no other tribe and tragically denied the same protections and resources enjoyed by every other federal tribe. Since I came to Congress, I've proudly championed federal recognition, yet despite broad bipartisan support, Congress has failed to send this legislation to the President. This is unacceptable, and it's past time we right this wrong once and for all. I'd like to thank my friend, Representative David Rouser, for leading this must-pass legislation to give the Lumbee people the long overdue federal recognition they rightfully deserve. I'd also like to thank Chairman Bruce Westerman and his incredible hard-working staff. I urge my colleagues to join us in support of this legislation. Thank you, Mr. Speaker. I yield back.
Gentleman yields.
Mr. Speaker, I yield 2 minutes to the gentleman from North Carolina, Mr. Bishop.
Gentleman is recognized.
I thank the gentleman, and Mr. Speaker, this is my final week in Congress, and many come to the floor and ruminate over their service. As for me, I can't think of a better way to spend my final words on the floor than in support of recognition for the Lumbee Tribe. The Lumbee have been pursuing justice since the mid-1800s. As I've previously stated on the floor some of the specifics of the Lumbees' Native American heritage, their struggle as a people against racial discrimination, and their deep and abiding community orientation around the life-changing power of education, especially represented by UNC Pembroke. I've talked about their rich tribal culture, the tribal council, the warriors' ball, Lumbee homecoming, the powwow. I count among my greatest privileges in Congress having been designated an honorary Lumbee warrior. I've explained the abomination of the recognition legislation of 1956, which acknowledged the Lumbees' nationhood while explicitly denying them the incidents and benefits of the status extended to other American Indian tribes, the epitome of arbitrary and capricious governmental action. And although Robeson County, the historic home place of the Lumbee, passed into Mr. Rouser's district in 2022, Lumbee recognition remains the unfinished business that is closest to my heart. I've been pleased to help introduce President Trump to the Lumbee and am proud to count him a vocal supporter of this legislation. I'm certain that progress toward righting this historic injustice has occurred over my 5 years in the House, and I'm pleased to say that victory is in sight. So let my final words here be thank you to the Lumbee for the honor of representing you here and for your friendship. And to my colleagues, let's pass Lumbee Fairness Act now. Vote for the bill. I yield back.
Mr. Speaker, I yield 5 minutes to the gentleman from Oklahoma, my friend, Mr. Burkeen.
The gentleman is recognized.
Thank you, Mr. Speaker. I rise today in opposition to the Lumbee Fairness Act because of the $750 million it's unpaid for in cost and how it undermines tribal designation based on merit, a 100-year history where merit drives and not politics. While I respect the hard work of my colleagues from North Carolina, and I have no doubt about their intentions with this legislation, the Lumbee Fairness Act would represent a lack of fairness for all historically recognized Native Americans and a lack of fairness for the merit-based process for federal tribal recognition. I am a card-carrying member of the Choctaw Nation. My family can trace its lineage to the time of the Indian Removal Act and the Choctaw Trail of Tears. Oklahoma is a Choctaw word. I'm one of only 4 current Native American members in the entire House of Representatives. I harbor no ill will towards any people who seek federal recognition for themselves and appreciate the hardship of going through the federal recognition process. However, we must also acknowledge that tribal-federal relations have a near 250-year history rooted in our Constitution, is found in Articles 1 and in Article 6 of that Constitution. There are 2 centuries of tradition showing how the founding generations and those following after dealt with the issue of federal treaties and with tribes. The recognition process is robust. It is designed to ensure only people who can prove themselves as historically tribal are designated as such. The Lumbee people have attempted to gain recognition via this process for 130 years, and each time rebuffed by the Bureau of Indian Affairs. Proponents of this bill argue the Lumbee are not eligible for the merit-based tribal recognition process. However, the latest ruling on this from the Department of Interior, latest 2016, says that the Lumbee are eligible to go through the merit-based recognition process. We should let that merit-based process go forward instead of replacing that time-honored process with a vote on this floor and what's popular. Congressional passage of this bill sends a subliminal message to historically recognized tribes all over the country that politics trumps what we should be looking at within this situation, which is merit. That is why 141 tribes alongside the Choctaw, Chickasaw, Cherokee, Muskogee, Seminole nations, etc., have opposed this effort going back many years. With that in mind, Mr. Speaker, I request unanimous consent to enter in the record a resolution from the 5 civilized tribes opposing the goal of this bill and news article detailing the opposition of 141 tribes, recognized tribes, to the same effect.
Without objection.
If a tribe cannot prove the necessary documentation or receive federal recognition, they should not receive it by Congress's action. If the Lumbee have a historical record of being a formal tribe, if they have evidence of lineage to any particular tribe, if they had a formal claim to the land that they now occupy, why would the BIA repeatedly refuse to formally recognize them as a tribe? Whatever tribe may have occupied the land near the Lumbee River has long since dissipated. In fact, the 1956 bill that acknowledged the Lumbee as a people stated that the tribe around the Lumbee River had fully assimilated into the surrounding European communities during the colonial era, before the Constitution was written. The Lumbee agreed to the language in that bill in 1956 as a compromise. In return, federal government referring to them as a distinct people, they promised they would not seek formal federal recognition. I ask unanimous consent to submit to the record a copy of the 1956 hearing on the Lumbee bill, where a representative of the Lumbee stated they'd, quote, rather leave the county, end of quote, than accept a federal recognition status. That's a strong statement of promise. This bill undermines that verbal promise. Constitutionally sound agreements with the federal government must be adhered to. I think we should all agree to that. Nations fall apart where people walk back commitments to one another. The entire foundation of tribal federal relations today is premised on both sides upholding commitments, agreements, treaties made 2 centuries ago by our ancestors and our founding fathers. Why do we uphold agreements? Why do we uphold treaties? It's about trust. The cornerstone of tribal law is adherence to promises made hundreds of years ago. The Lumbee must be held to that standard, that commitment from 70 years ago. Granting the Lumbee tribal recognition sets a dangerous precedent. Granting them recognition by going around this 100-year-old process opens the floodgates for anyone who claims themselves a tribe to receive special benefits through politics, not merit. This will lead to a vast, irresponsible increase in federal spending.
Gentleman's time has expired.
I yield the gentleman another minute.
Thank you. I appreciate that.
Gentleman is recognized.
And ending with this will lead to a vast and irresponsible increase in federal spending. I'd like to respectfully refute a claim that this does not increase spending. With the CBO report from the 117th Congress scoring the exact same bill at a cost of $726 million over 10 years, for which, Mr. Speaker, I ask unanimous consent to submit that, along with the text of the resolution for the 117th Congress. Just because CBO this time around didn't score it doesn't mean it doesn't have a cost. It just means they didn't score it. The score from it 2 years ago, $750 million. And with that, I thank the gentleman and I yield.
Gentleman yields. Gentleman, Arkansas is recognized.
Mr. Speaker, I yield 2 minutes to the gentleman from North Carolina, Mr. Edwards.
Gentleman is recognized.
Thank you. Mr. Speaker, I rise in strong opposition to H.R. 1101, the so-called Lumbee Fairness Act. I'm proud to represent North Carolina's 11th District, which is home of the Eastern Band of Cherokee Indians, a tribal nation rich in culture, language, and sovereignty that is a true treasure to the state of North Carolina and to the United States. In stark contrast, it must be noted that the Lumbee community has no standing treaties with the federal government, no reservation land, and no common language. The Office of Federal Acknowledgement under the U.S. Department of Interior, or OFA, was established to provide a rigorous process that groups seeking federal recognition must go through, including genealogical and historical research. This legislation wholly bypasses the OFA process, and I believe that if the Lumbee community truly had a legitimate claim for federal recognition, they would go through that process like other prospective tribes have done. Let us not circumvent our rules to bring this bill to the House floor with the purpose of circumventing the rules for an alleged tribal nation. In my view, this legislation should have gone through the committee markup process before being put on the floor as a suspension bill. as has been done for numerous other bills this Congress, before giving consideration to the full House. If the administration or Congress allows the Lumbee to bypass the OFA, it sends a clear message that other groups with dubious claims for tribal recognition can also avoid the deliberation and scrutiny that the OFA petition process is designed to provide. I urge my colleagues to vote no on this legislation. Mr. Speaker, I yield back.
Gentleman yields. Gentleman's recognized.
Mr. Speaker, I have no further requests for time. I'm prepared to close, and I reserve the balance of my time.
Gentleman reserves. The gentleman is recognized.
Mr. Speaker, as someone who represents tribal communities in Los Angeles County who also seek recognition, it is tough stuff when tribal nations are fighting with one another. I hope that we can find a both and rather than an either or to many of these discussions. I rarely find folks are trying to fake it and pretend that they are Native when they're not. I urge my colleagues to support the legislation, and I yield back the balance of my time.
Gentlewoman yields. The gentleman from Arkansas is recognized.
Mr. Speaker, H.R. 1101 would extend federal recognition to the Lumbee Tribe of North Carolina, ensuring its members are eligible for the services and benefits provided to members of all federally recognized tribes. Again, I thank the sponsor for his work in this legislation, and I yield back the balance of my time.
Gentleman yields. The question is, will the House suspend the rules and pass the bill H.R. 1101 as amended? Those in favor say aye. Aye. Those opposed say no. In the opinion of the chair, 2/3 being the affirmative.
Request the yeas and the nays.
The yeas and nays are requested. All those in favor of taking this vote by the yeas and nays will rise and remain standing until counted. A sufficient number having risen, the yeas and nays are ordered. Pursuant to Clause 8 of Rule 20, further proceedings on this question will be postponed.